Hey there.
Hi.
I'm a little nervous because I'm a young associate and I decided I would write most of this out for you, but you've got questions, you just go ahead and ask. You might recall this is the situation in which our client built a house 12 feet farther north than the contract stated.
Right.
And as a result, our guy was unable to construct the lap pool that the buyers had contracted for. Now, our experts are telling us that a lap pool adds no value to the property. Most people don't want it, along with the expense and hassle. And our client's willing to build a nice pool in front of the house for a reasonable price, but the buyers don't want that. So
Obviously.
apparently they're about to sue. Now, there's no question our client's breached here. And in fact, the buyers are alleging that they did it knowingly and deliberately to avoid paying some extra money for excavation. That was the original problem. So our client probably owes something in damages, but the question is, what's the remedy going to be? Our client, of course, is not going to charge for the $30,000 in costs avoided by not having to construct the lap pool. And since the buyers, well, the contract price was $437,000. Put that here for you.
Okay.
And the buyers have paid $385,000 to date. And that would mean that actually the buyers owe our client $22,000, less perhaps $10,000 as nominal damages for the breach. I made a little spreadsheet, you can see it here,
Right.
that shows all the calculations. And that way the buyer would end up paying about $407,000 for a house that was worth about $407,000 on the market. A lot of people would think that's pretty fair, and if this case goes forward, that's what we're going to have to persuade the court of. But these plaintiffs don't want that, and they also don't want any sort of refund of the $385,000 and the opportunity to buy a house elsewhere in the subdivision.
They want as they asked for it.
Yeah, those
Along
lots,
the
apparently the other lots aren't adequately wooded. I mean, they're kind of fussy, but that's the way it is. And at least according to their attorney, the buyers have been losing sleep over the matter and getting incredibly upset. And I'm sure we'll hear nightmares at deposition about getting fatter and fatter as they can't swim in their precious lap pool. Apparently what the buyers want is for us to tear down the house and rebuild it on the spot called for by the contract and then build the darn lap pool.
So what does the law provide?
Well-
you know I'm an immigration attorney, so
All
you got to bring me up to speed here.
Okay, all right. So, and by the way, I should say, it's going to cost, according to our experts, $550,000 to take this house down and rebuild it.
Does the law require
Well-
us to do that?
It's a tough one. The standard measure of damages in contract cases, you remember, is expectation damages. And the breaching party, our guy, is supposed to put the non-breaching party, the buyers, in the same position they would have been in had the contract not been breached. Okay? But what if, as here, the marginal cost of putting the non-breaching party in that same position exceeds the marginal economic value of doing so? I mean, originally it might have made sense to build the lap pool, but what happens if, because of an accident, or maybe here the breaching party's deliberate actions, it no longer becomes economic to do so? And if the breaching party's forced to pay the cost of completion, rebuilding the house as damages, rather than just the diminution in value, the non-breaching party might get what's called a windfall. That is, the non-breaching party, our buyers here, might be better off as a result of our breach of contract than if the contract had just been performed. And in fact, think about what that buyer's going to do if we pay him $550,000.
He's not going to put in the pool.
Exactly. He's going to pocket the money, not rebuild, and he can, have himself chauffeured to a health club and swim to their heart's content. Do that a lot for $498,000 or $500,000. So I did some research, and as you requested, I kind of focused on national cases rather than ones specific to our state. So let me start with one from Alaska. What happened there was these people wanted a concrete underground house. And the price was supposed to be $65,000 for the concrete pouring. but the contractor screwed up. And as a result, in order to dig it up and redo it and everything, apparently it was going to cost $400,000. Don't ask me why. And the lower court instructed the jury that the owners were entitled to cost of completion, that is the $400,000 measure, if one of three things was present. The concrete was of special significance, the buyers were in fact likely to rebuild, or it was dangerous. But the appellate court said that wasn't the right way to instruct the jury. The buyers had to show, according to the appellate court, that the buyers were in fact likely to rebuild,
Right.
if given the opportunity to do so. And then they also had to show that it was, this concrete thing was of special value or it was actually dangerous. So here we can tell the court, this makes some sense, and what we might be willing to do is to put the money in escrow, pay the cost of completion, stick it in escrow, and then if the buyers actually rebuild, they get that money. And my guess is that they won't do that, that they'll compromise with us and say, give us $100,000 out of the escrow, release the escrow, and we'll go away. I just have a hard time thinking that they're really going to spend all that money. But it's
And
a risk.
time.
It's a risk. It is a risk, yeah. The other thing is, it's not dangerous to live in a house which doesn't have a lap pool. So maybe under the Alaska instructions, we could actually prevail. The other good thing about that Alaska case is the court rejected emotional distress damages in house construction cases, which might be a little, people get all worked up about their houses, but the courts seem to confine emotional distress to very special cases like screwing up a burial or other areas of specific emotional concern. So I think we're probably okay on the emotional distress damages. It's not usually awarded in contracts anyway. All right, so let me tell you about some of the other cases I found. They're all sort of this comedy of errors. One's from Indiana, and the buyer there, he wanted a basement that had high ceilings. And instead of the conventional, basements kind of have low ceilings. So the builder did the usual low ceilings, and then the house gets built on top of it. So it's like going to be really hard to redo it. Apparently they're going to have to jack up the house in order to do this. And for most people in the world, it doesn't matter. Most people in the world don't care if the basement has medium-low ceilings or high ceilings. And the court said that you could only get cost of completion damages if the defect could be remedied without taking down a substantial part of the building. Now there they said actually it could be done without taking it down, but here it's, according to these buyers, they want the thing demolished. And so I think under that Indiana case we may actually be in good shape. We're going to need to line up an expert that says that in order to do this we're going to have to destroy the whole thing, which seems pretty obvious to me. Okay, the other thing is this old case involving a gravel pit. And the idea was that a rival gravel manufacturer was supposed to dig gravel out, and then maybe the other party was an environmentalist or something. They wanted it put back in its natural condition. And the first gravel company deliberately refused to do it. They just left the gravel pit as a gravel pit. Now, apparently, nobody else cares, and the value of land as a gravel pit is worth no less than the value of land with it filled in. I guess in this neighborhood, nobody cared. And so the question was, where, again, it's not economically sensible to rebuild, does the breaching party have to pay for the cost of putting it back as per the original contract? Or do you just get whatever little diminution in value exists as a result of the failure? And here, the court looked at issues of intent, and apparently the failure here was deliberate. And the court basically talked about how that was a problem. That's potentially a problem for us here if the buyers are correct that they did this on purpose, in order to save some money. And so that's potentially an issue for us if the court wants to apply that old case involving the gravel pit.
Did the other cases, the Alaska case, talk about intent?
No, they didn't. The Alaska case didn't talk about intent, and that Indiana case involving the basement didn't involve intent.
But it sounds like that one was unintentional from the way
It does. So we maybe should argue that intent doesn't generally play a role in the law of contracts, although there's this old case, Jacobson Young. I'm sure you remember it from your contracts cases. Contract professors seem to love it, in which the court talks about the role of intent. But anyway, I think, this is a case where we're going to need to work with the buyer and see if we can't tell them, look, it's unlikely that a court's going to award you cost of completion where it's non-economic, where you're going to have to totally destroy the thing, and where in fact everyone knows you're not going to rebuild. How about we give you, I don't know, pick some number, and all right, you'll go buy it with a slightly less wooded lot. You can plant a lot of trees for $100,000, and maybe they'll go away. The only other thing is, I don't know if this is my job or your job, but did anyone contact like an insurance, take a look at his insurance policies to see if there's some sort of errors and omissions coverage for this kind of thing on the builder? Because potentially they're exposed to $500,000 worth of damages here. And I think we need to talk to the client about whether they've got any sort of insurance for this.
It's a good idea. Let's do that.
Okay. So I know you've got another appointment,
Right.
and I'm happy to talk to you further about this.
Thank you for this briefing.
Yeah.